Good morning and welcome to Citizen Extra. My name is Wahiga Mwaura. Now, in the next 1 hour, the Supreme Court of Kenya will begin marathon hearings of two petitions, one filed by former Kilome Member of Parliament Harun Mwau and another filed by civil rights activist John Jomue together with Helef Khalifa. In summary, the petitioners are contesting the October 26 poll, arguing that the withdrawal of Raila Odinga from the case meant that the poll was void, among other issues. Mr. Mue and Mr. Khalifa argue that the IEBC did not conduct the fresh election in strict conformity with the Constitution and the applicable laws. Mr. Mue said going ahead with the poll deprived NASA of an opportunity to replace a candidate to face off with other candidates. On the other hand, Mr. Mwau, in a different petition, says the poll is void because the IEBC failed to subject the candidates to fresh nominations after the August 8th poll was invalidated. But in response, President Uhuru Kenyatta and IEBC state that there was no need of subjecting candidates to fresh nominations because the court only invalidated the declaration of the results and not the nominations which were conducted in March. Now, Chief Justice David Kenani Maraga directed yesterday that the hearing will start today at 10 a.m. And of course, welcome to the program. This is the 15th day of November 2017. Some very exciting days, depending on where you come from, on the legal front over the next couple of days. And of course, a judgment by the court expected on or before the 20th of November. That is next week, Monday. Let's cross over to the Supreme Court right away, where Francis Gashuri is on standby to give us an update. It was a late night for him and the whole team that was there because the court's pre-trial conference went on into the night as well. Gashuri, on one hand, some feel that the petitions this time around are of a lighter nature. But on the other hand, there are those who say that the court will have to determine very weighty constitutional matters. For example, the definition of a fresh presidential poll or the consequence of one candidate withdrawing. Talk to us a bit about that, even as you paint a picture for us of what Kenyans can expect from that court today.
Good morning, Wahiga. The 9th day of the 14 days that the Supreme Court has to hear and determine presidential election petitions challenging President Uhuru Kenyatta's re-election on the 26th of October in the repeat presidential election ordered by the Supreme Court on the 1st of September this year after the nullification of the election that was conducted on August 8th, 2017. And yes, this is the day that many people have been waiting for to hear the arguments coming from both sides of the petition. That is the petitioners and the respondents in this matter, as well as the interested parties who have been admitted to make their submissions in this petition and eventually enable the Supreme Court judges, the 6 of them, to make a determination on the fate of the presidential election that was conducted on the 26th. To determine whether Kenyans will be returning to the ballot yet again for the 3rd time in under 6 months, or whether President Uhuru Kenyatta and his deputy William Ruto will be sworn in on the 28th of November 2017 at the Kasarani Stadium. And lawyers are already making their way here at the Supreme Court. Yesterday, the pre-trial conference was conducted late into the evening, and quite a number of issues were sorted out. A number of people were kicked out from their petition. Primarily, the National Super Alliance, NASA, they were struck off from their petitions. Remember, they had been listed as one of the respondents in the petitions. And so that matter is now sorted out. And so it's now clear the number of petitions that the Supreme Court judges will be dealing with: 2. The one by John Jomue and Helef Khalifa on one hand, and the other one by former Kilome Member of Parliament John Harun Mwau on the other hand. And the parties in the case are now clear. They have even been allocated the amount of time that they're supposed to make their submissions. And the issues for determination are also clear. And so the judges now will have to hear what the various lawyers representing the various parties will have to say before they can retreat and come up with a ruling that they have to deliver on or before Monday, the 20th, Wahiga.
Maybe just to briefly walk us through a little bit about what happened last night, especially when the judges came back after a bit of a break to give their rulings on various applications that were made. On one hand, NASA's application, which was read out by Justice Ojwang, they will not be participating in this particular process. And also, on an interesting matter, the Attorney General's application, on one hand, we see that he was accepted as an interested party, but not as an amicus curiae. This may have confused some. Maybe you can help us clarify some of the determinations that the judges made late into the night.
One of the things that we have to be clear about, Wahiga, is that NASA had not filed any petition in relation to the October 26th presidential election. Actually, NASA had been listed as one of the respondents, if you like, one of the accused persons in these petitions, bearing in mind that the other respondents are IBC chairman, President Uhuru Kenyatta. So NASA had been listed as one of the respondents, and it was the contention of President Uhuru Kenyatta through his lawyers, led by Fred Ngatia, that NASA should not have been included in the petitions, that it had no locus, it should not have been included as one of the respondents, and that the argument of the President Uhuru Kenyatta's legal team is that the petitioners, that is John Jomue and Helef Khalifa, are quote-unquote surrogates of NASA, and so the NASA should not have been included in the petition as respondents. And the judges seem to agree with the Ngati and his team, and that's why NASA was struck from the petition. And when we spoke to the NASA legal team led by lawyer Paul Mwangi, they said they were satisfied with the decision of the court because it meant that neither NASA nor any of its principles will be mentioned anywhere in the petition, and that they don't have to be here because they will not have anything to defend. Remember, they had been listed as one of the respondents or an accused person, as I said earlier, and because the specific paragraphs where NASA was being cited have been struck off, so they said they are satisfied with that decision, and they took it as it was. And so also remember that some of the documents that had been filed by Helef Khalifa and John Jomue as part of their evidence, primarily the memos that came from IBC. Remember the period there was an altercation between the IBC chairman and the CEO Ezra Chiloba, the memos that were exchanged. They had been included or had been brought together by the petitioners as part of their evidence, and so the judges made a decision that those memos were struck off from the documents or the bundles of documents, so they will not be used anywhere. Also, James Gondi's affidavit was also struck off. And yes, Attorney General Professor Githu Muigai had applied to be joined as an amicus or a friend of the court, but the judges declined that request, but he was admitted as an interested party, so he will be making submissions. And when you look at the application that the Attorney General made, he speaks opposing the petition on various grounds, and so as an interested party he will be making submissions and also making his position insofar as the petitions are concerned. So that is the clear position as it is now. The parties are now clear, and all we wait for is 10 o'clock so that the judges and the legal teams can come and begin arguing their matters. Remember, Wahiga, the judges are not strangers to this petition or the petitions, because the moment the petitions were filed on the 6th of November, the judges have been going through the petitions. And when the responses were filed by the respondents, they have also been going through them because they were filed on soft copy and also the hard copies that were submitted. And so they are familiar, so to say, with the petition and the responses coming from the respondents. All that they want to hear today in the course of the 9 hours that have been spread over is that they want to hear what the lawyers will have to say, and in case they have any clarification they want to seek, they will be making that point to the lawyers so that they can get clarification on various matters that are coming up as part of the grounds for the two petitions.
Well, thank you so much, Francis Gashuri, for making that very clear. Another 40 minutes or so, we will have to wait. But I know a bit later on we'll be coming back to you and your fellow, if I can call him amicus curiae, Sam Gituku. We'll be getting more updates from that team at the Supreme Court. Well, before we delve into what happened last night and what we can expect, rather what happened yesterday and what we can expect later today when the court sits from 10 a.m., let's take a look at what's happening in other parts of the country and the world as well. We start in Zimbabwe, where Zimbabwe's military has read out a statement after taking over the national broadcaster, that is the ZBC, saying it has taken action to target criminals. However, it said that this was not a military takeover of government and President Robert Mugabe was safe. Heavy gunfire and artillery were heard in northern suburbs of the capital Harare early on Wednesday, that's earlier today. Zimbabwe's envoy to South Africa, Isaac Moyo, earlier dismissed talk of a coup, saying the government was intact. The statement read out by Major General Sibusiso Moyo came hours after soldiers overran the headquarters of ZBC. He said, and I quote, "We wish to assure the nation that His Excellency the President and his family are safe and sound and their security is guaranteed." I believe we have his statement and we can listen to it now. Okay, that should be coming up just now, what Major General Sibusiso Moyo had to say early this morning on behalf of Zimbabwe's military.
We wish to assure the nation that His Excellency the President of the Republic of Zimbabwe and Commander-in-Chief of the Zimbabwe Defense Forces Comrade R.G. Mugabe and his family are safe and sound, and their security is guaranteed. We are only targeting criminals around him who are committing crimes that are causing social and economic suffering in the country in order to bring them to justice. There is a plan by the same individuals to influence the current purging which is taking place in the political sphere to the civil service. We are against that act of injustice, and we intend to protect everyone of you against that.
It's not quite clear what exactly is happening in Zimbabwe. Some media houses, or especially foreign broadcasters, are calling it a coup of sorts. But that's a statement from the military. That is what we have in terms of now. We'll have to just keep looking out to understand exactly what's happening in the nation of Zimbabwe. But now, closer home, we want to cross over to the Kenya School of Monetary Studies, where CS Matiang'i is expected, or has probably already begun, addressing the leadership of public universities on the review of the growth and development of public universities. The agenda of this meeting is to assess and review the financial and human resource status in public universities in Kenya. To get a better update, let's now bring in Hassan Mugambi, who is at the Kenya School of Monetary Studies. Hassan, good morning. Has that forum started, and what more can you tell us about it?
Well, a very good morning to you, to Wahiga back in studio. The forum is yet to start because they are waiting for the chief guest who is making his way here. That is the Cabinet Secretary for Education, Fred Matiang'i, who will be coming here to have this conversation, an all-important conversation with the leadership of public universities. Remember, they want to chart a way forward and address their challenges and craft a roadmap towards addressing challenges facing especially the human resource management of public universities. Remember, public universities have been in the past characterized with a lot of industrial action in as far as the welfare of the workers, from teaching and non-teaching staff of the public universities. Their welfare has been a thorn in the flesh of the government, CBA after CBA, and industrial strike after industrial strike. Now that is the kind of conversation that Matiang'i is going to have with the different vice chancellors who have already assumed their seats in this particular auditorium in the Kenya School of Monetary Studies right behind me, and they will be channeling out their frustrations and as well as letting out the challenges and also some of the strides that they have made in as far as the administration of public universities is concerned. So we're waiting for him, and he is going to make his way here very, very soon. And it is a meeting that also is expected to have an array of recommendations which, if implemented, will see a smooth running of public universities in the country.
Thank you so much, Hassan Mugambi, for that update, reporting from the Kenya School of Monetary Studies. Let's now go back to our big story of the day. Of course, all eyes on the Supreme Court. Francis Gashuri has given us an update, but we want to review a little bit about what the judges had to say in terms of rulings, or the rulings they gave out or read out yesterday to various applications that were made by different parties, requests by either the petitioners or respondents, but also applications by those who wanted to be enjoined as interested parties or as amicus curiae as well. The judges went through most of them, although there are a few of which they said they will give a direction today. But let's take a look at let's actually first start by listening to what Justice Ojwang had to say in regards to the National Super Alliance yesterday. Let's listen. And of course, they were not petitioners in this case. They were actually a respondent in one of the matters, in the matters rather. And this is what he had to say about their position in this whole matter. Let's listen in.
Upon perusing the application and reading the written submissions in support of the application, and upon considering the fourth respondent's reply to the same, having considered the oral submissions and arguments by a unanimous decision of the court, we find that NASA cannot be sustained as a respondent in this matter. In view of the limited time, the court will give detailed reasons for this decision on notice. Any references to NASA?
So just in case you do not see advocates of the National Super Alliance in the courts today, that is the reason why, and my guest will help us to further understand the thinking of the court behind this and what it means. But in addition, the Deputy Chief Justice Mwilu spoke about or read a ruling on the Ekuru Okot application as an interested party, and on the Jubilee Party application also to be enjoined in one of the matters. Let's listen to what she had to say.
I have the application by Ekuru Okot, and this is our unanimous ruling that he meets the criteria in Momo Matemo and Muruatetu and is therefore joined as an interested party. Chief Justice, I then have the one for the Jubilee Party that seeks to be joined. The Jubilee Party has applied to be joined as an interested party in petition number 3 of 2017. In the course of hearing that application, counsel for the respondents have raised a preliminary objection challenging the jurisdiction of this court to entertain the petition. Today and for the next 2 to 3 days, this court will be engaged in hearing 2 petitions under Article 140, challenging the election of the Honorable Uhuru Muigai Kenyatta and the Honorable William Samoei Ruto as President and Deputy President of the Republic. Petitions under Article 140 are time-bound litigation which must be determined within 14 days as required by Clause 3 of that article. This petition does not challenge the election of the President-elect. It is brought under Article 163, Sub-Article 3 of the Constitution. It is therefore not a time-bound petition under Article 140 of the Constitution that we must hear within 14 days. It cannot therefore be heard alongside petition numbers 2 and 4. It is accordingly taken out of the course list of the matters to be heard between today and the 13th of December.
Indeed, let me now introduce my guest in studio. I'll start at the far right. Joy Mdivo, Advocate of the High Court. Welcome to the program.
Asante. And
right next to her, Joseph Simeha, Political Analyst. Welcome to the program as well.
Thank you, Asante Sana.
Thank you so much. If you look at today's headlines, you see headlines or the way they've described them that might be slightly confusing to those who did not follow yesterday's proceedings or who have not quite understood exactly what happened last night. So even as we listen to this, on one hand you see Jubilee and NASA loss is one headline, but you then see a different headline that President Uhuru Kenyatta elbows NASA or Raila out of the petition. So which headline is accurate? What's the actual position of what happened yesterday? And I can start with you, Joy, your interpretation.
The headlines give, it's an simplified version of what happened yesterday. Now, when a party files a suit, sometimes you'll find that they enjoin people to the suit who they imagine would have a sufficient interest in the matter to be able to push the narrative forward.
So let's be practical about it. Jonjo Moe, Helef Halifa.
Yes.
And then petitioners, so respondents were IBC chairperson, IBC,
yes.
President Uhuru Kenyatta, and NASA.
Yes.
Okay, go ahead from there.
And so now, because as far as they were concerned, this involved these several parties. Now, the objection now to the sort of headlines we're seeing is when you oversimplify it and say Uhuru has elbowed, it was not a function of Uhuru to elbow anybody in or out. It was a function of the court to determine, okay, fine, was so-and-so correctly enjoined as a party to this suit? And that's what the court said, look, even if you insist that they participate, in this particular instance, we do not see what value they're adding. The petitioners have filed very specific allegations against people who they have already enjoined in the suit, and anybody else now would be seen as coming in to sort of muddy the water, so to speak.
Okay.
Of course, there's the argument that it would have been beneficial as maybe amicus or otherwise, but because they were enjoined as a party, the court made a determination as such. And that's why they even went ahead to say, by the way, just expunge them from the record. Let's deal with this with the petitioners. versus the other parties who are directly involved in the matter.
Okay.
And so it's not a matter of NASA winning or NASA losing or Jubilee machinations. It's actually a function of efficiency. The court just wants to be, let's be clear who we are talking to and what we are dealing with.
And anyone who does not need to be here at this moment,
let them not be.
Let them not be present.
They have several petitions to deal with. They only still have 14 days, so they have to be very
actually less
selfish.
than 14 days. They have
yes,
until Monday.
They have to be very selfish with their time, and not just that. They have to get to a place where they don't entertain every frivolous application. That's why you're seeing they're being very strict even on time, on what was filed, what was not filed, because they realize if they're going to deliver, they have to keep the eye on the ball.
Okay.
And I think that's
although
what
those who filed applications do not feel that the applications were frivolous, and there's one gentleman in particular who made it very clear, and I'll be playing his clip shortly. But Joseph, I can allow you to weigh in on this as well. Your take on how the different newspapers have termed yesterday's proceedings versus what is actually the reality of what the court actually said yesterday. What's your take?
Yeah, thank you very much. I think for me is actually an indictment, a self-indictment of the media, or some kind of mischief. Because when you look at the one where they say Uhuru elbows out Raila or NASA, if you like, did not invite themselves to the case. They were, in fact, to put it in plain language, they were, in quotes, sued. They were the party, one of the parties sued by the petitioner. No, that's not really the term used, but just to help people understand. They were one of the parties that the petitioner is saying, you must respond. We are accusing you. So the petitioners were actually accusing NASA of having contributed to whatever they are citing as the basis of their petition, and I suppose it's like the environment of the election, the environment in which a free and fair election could not take place. So NASA did not invite itself. So you cannot talk of a loss. NASA therefore had responded, had defended, if you like, in quotes, itself in that petition. Unlike NASA, Jubilee actually made an attempt to invite itself, to request the court to allow it to participate as an interested party. A party who, yes, a party that feels like some of their interests or interests are being touched upon by that case. So they should be allowed to be present and to participate. Every so often they may wish to raise something, or they may actually be asked by the court to respond to something. So the media projects this in very bad light, and it's unfortunate because then it causes confusion. What would have been an accurate headline for you if you were managing editor in one of these stations? What would you have wanted to see on the front page of a newspaper this morning? I would just say NASA removed as a respondent. Now, in fact, I would say that. I would say that. NASA excused from the case. Excused from the case? Yes. Joy? Because NASA had been, a burden had been put on NASA. Yes. We are accusing you. Respond. And now this burden is, and NASA had responded, and I suppose, not I suppose, because the Uhuru Kenyatta lawyer actually complained that in NASA's response, NASA had raised some issues, some, if you like, new evidence that was prejudicing their case, the case of their client, who is Uhuru Kenyatta. So they were afraid that if NASA continues, even though it's being accused, if it continues to be party to this case, to be a party in this case, when the moment comes for the judges to look at what NASA has filed and for NASA to make oral representations in court, they will prejudice Uhuru Kenyatta. So they were afraid of NASA being a respondent or an accused in courts in this case. Okay, do you agree? Is that how what you'd have preferred to see?
As for the headline?
Yes.
The headline, I would have kept it simple. Pre-trial conferences conclude. Because that's what happened yesterday. We had the pre-trial conferences, and we have looked at what is going to be on the cause list, what is not going to be on the cause list. So, but that's basically what happened yesterday. The trial proper starts today. So what happened yesterday was sort of, let's find out who are the players, let's lay down the ground rules, let's find out what stands, what doesn't. Because even some of the applications that were taken out, it's not that they'll not be heard. It's just that they'll not be dealt with during this window because they have felt what touches the election is this. Let's deal with this because this is time barred by the Constitution and by the Supreme Court rules and by all other procedures. Okay. So when the headline is put now with the parties and the whatnots, it becomes sideshows because today is when now we delve into the meat of the petition to find out is there merit. So everybody puts their evidence and there's responses. And then also what Simeka says is actually correct. When you have a party feeling aggrieved then they are entitled to petition the court for sufficient time to respond. So if the court decides, you know what, if I listen to you guys, I'll get confused, it tells you, you know, you are welcome to come back later for us to have an intellectual discourse. But for now, I will not hear you. And I think that's what we saw happening yesterday.
Okay,
well, I was just going to say, coming back, you know, to the media, I think you guys the media loves, perhaps for it to sell, loves to present some kind of confrontation, some interesting confrontation.
Where they
I saw on TV screens yesterday the picture of Raila versus Uhuru. What's that?
For what adventure? Should have been John Jamue there and Harun Mwau.
Yes, it should have been John Jamue and Khalif Khalifa and Mwau versus Uhuru and IEBC. But yesterday in the morning, you see, you know, on your screens, on TV screens, they were running Raila versus Uhuru.
Once again, just like you know, after the August 8th poll.
Yes.
Okay.
Yes. So I suppose it's to do with just wanting to excite people, for people to pay attention, so they can buy that newspaper and then find out what is inside it.
We're going to take a break from that. Let's listen just a little bit to what else happened last night. Let's listen to what Justice Njoki Ndong'o had to say about the Attorney General's application, where he was accepted, and of course, where he was struck out. Let's listen just a little bit to what she had to say yesterday. Njoki Ndong'o? Yeah, let's play the Njoki Ndong'o clip from last night. Okay.
In summary, there is an application for interested party by the Attorney General. We have looked at the application, and upon considering the following arguments by the applicant on the merits of the application, that one, his application meets the criteria for joinder, that the instant petition raises grave allegations touching directly on the roles played by state and public officers and officers regarding their manner of participation in the fresh presidential election, that some of the issues raised in the petition touching on the conduct of state and public officers were live in cases in which he has represented the national government. We have, having considered those grounds, and by unanimous decision, we find that the application meets the criteria laid out in the cases of Mumu Matemu and Moroatetu, and therefore the applicant qualifies to be admitted to these proceedings as an interested party.
The other applications have been made here. Some we have allowed. We have even dismissed the AG's application.
All right, before I allow my guest to comment on that, Joseph, just to clarify, one of my producers has informed me that the clip you saw was not at this station of
Yes, I just said TV station.
I was waiting for that clarification.
So clarify for your viewers.
And I've gotten that, but it's good for our viewers to know that this is the channel that they should watch if they want to know the true picture and not other stations.
Okay,
but nevertheless,
fair enough.
For the Attorney General, accepted as interested party, but not as amicus curiae, is that an accurate description of his role in this petition?
Yes, and you know, for the Attorney General, it's difficult to completely lock him out, because being the head of the titular head of the bar, as well as the chief government advisor, is one of those people whom you need to listen to what he has to say if it sheds any light on the situation. But we have seen the courts being very deliberate, not just now, but even in previous petitions, so to sort of limit how much leeway he has in the participation. Because what we saw in the 2013 petition was that the Attorney General sort of became the star of the show.
Run away with the show,
and it got to a place where those who had actually gone to court did not have a sufficient time as they should have because of accommodating too many people. And this is something I have to laud the court for, because in making these allowances but with boundaries, it allows also the engagement to be more beneficial, because now somebody doesn't go on a fishing expedition, they know exactly what they're coming in to give. But as an interested party as well, for me it was a bit curious, because he's in charge of the entire country, is not interested in one direction. But when you box him into interested party, the insinuation then becomes that he's coming in on behalf of the ruling coalition, because he is in government and he is in the job courtesy of the current administration. So it also lends, it's a bit of a fudgy line, but the thing that I am grateful for is that with the parameters that have been laid, even his engagement in this particular matter, much like we saw with the LSK and with the AG in the concluded petition of the one that concluded in September, is that they have an opportunity to just give the input that the court needs, rather than the input that they think the court ought to hear, which is in my opinion, it's a step forward. So the petitioners have ample time to lay their case. If they have a case, prove it. If they don't have a case, we all can be able to see. And then we can arrive at a conclusion that is satisfactory in a manner that can be understood.
Okay. Definitely the Attorney General finds himself on slippery ground because in his move, we expect him to oppose the petition. And by doing so, then many will say then that shows that he supports one side over the other. Again, we'll have to wait and hear what he'll have to say about that because I'm sure that will be part of his submissions. But Joseph, you can come in as well.
Yeah, I think it's important to make clear the difference between amicus and interested party. Amicus is a friend of the court, someone who offers presentations to the court to help clarify either principles of law, principles of the Constitution, and anything else around that case that will help the court, make an objective determination. So amicus presumes that you are neutral. You are only assisting the court. You do not support or oppose any of the parties in the case. As opposed to amicus, an interested party is actually someone or a legal entity with an interest, that case is touching on their interest. So, and here they've made it clear from what they read, what Njoki Ndung'u read, the government has an interest because certain accusations have been made against agents of state, like the police, like the county commissioners, etc., etc. And he's the chief legal advisor of the government. So therefore he's there, if you like, to represent the interest of the government, because the government has been, government agencies have been mentioned adversely in the case. Who then would defend them? Will the police go there to deny those allegations? Will the county commissioners go there to deny those allegations? No. It would be this interested party who has a right to be partisan, actually. Because yes, he has a right, not in favor of Jubilee or in favor of IBC, but in favor of the government, to defend the government position, where the government is mentioned adversely. In my recollection of 2013,
do you agree?
It is true.
In my recollection of 2013, the Attorney General, Professor Muigai, was admitted as an amicus, but he ended up being a star as an interested party. Yeah, he ended up starring as an interested party instead of starring as an amicus.
Okay,
so, but it's important also to realize the role of amicus is very important. Because when parties come to court, they always present their side. And there's usually some points of law that are lost in between, who nobody really wants to address. And that's where amicus become important, because they are there to address the court on that which nobody is saying, to address the elephant in the room, as it were. And so when you have the role of amicus curiae, as Simeka correctly points out, you must of necessity walk the line in the middle, such that if this side omit to say something conveniently, you must point it out. And if this side omit to say something conveniently, you must point it out. So it's true, this time around the AG has been boxed into his role as Attorney General rather than coming in as legal advisor, which I was saying earlier also helps him to focus on what he's supposed to do rather than trying to address the court on whatever.
And ideally saves the time of the court as well.
A lot, it does.
If you remember the LSK, sorry for this.
We need to take a break. Okay, go ahead.
Just a very quick one. The LSK actually this time said, look, we are not applying to be amicus because the principles of the Constitution, of relevant laws and so on that would apply, that would come to clarify in this case, we already did in the previous petition. So we don't need to come and take time. Those things are on record. The judges can go back and check the clarifications that the LSK made and so on. So the LSK doesn't really just need to come there and fill up the time and so on. And that's why they said, okay, look, we are staying out. We don't think there's any new value that we will add as amicus.
Okay. On that note, I think it's time we take a quick break. When we return, I will not be here. Anduta Kiguta will be joining us. We'll take over the panel here. And we certainly hope that we've clarified a little bit about what happened yesterday at the Supreme Court pre-trial conference, and also what you can expect later today from 10 o'clock, which is actually in the next 15 minutes or so, as that court is expected to start hearing those two petitions. Initially, there were about 5. But after what happened yesterday, what we know now is that 2 petitions, one by former Kilome Member of Parliament Harun Mwau and another by a civil rights activist John Jomue and Helef Halifa, is what the court will be listening to today. We take a quick break. Keep watching Citizen TV. We'll be right back.